Bien, buenos días, buenas tardes y buenas noches.
Good morning, good afternoon, good evening, wherever you are in the world. Greetings. It's for me an honor to be able to moderate such an important event. My name is Monica Chujiwalinga. I'm a Quechua. I am the Deputy Director for Latin America and the Caribbean of IPRI, and it's an honor to be able to share and moderate this space, such an important space like the launch of the Digest. So now we're going to give the floor to this event. We would like to introduce one of the first persons who are going to do a summary of the launch of the Digest on Legislation and Case Law of IPRI. I would like to introduce Ruka from the Sulawesi. It's the first woman, which is the Secretary General of the Alliance of Indigenous Peoples of the Archipelago, the largest organization of indigenous peoples in the world at a national level. She's well known for her dedication to the movement in favor of the indigenous rights. In 1993, her parents organized a meeting which was considered as the starting point of the movement in Indonesia. Ruka has a BA at the Hasandi University and a master's degree in political science from the Chulalongkorn University in Thailand. So now we're going to give her the floor. Go ahead, Ruka.
Thank you very much, Kuresumanga, Sister Monica. Good evening from Indonesia, Bongi Melo, in my language, Toraja. I'm Ruka Sombolinggi, I'm the Toraja. And good afternoon for those in Geneva, and good day for everybody. Thank you very much, and congratulations for IPRI. Well, I'm actually congratulating also myself as a part of the global board of director of IPRI. IPRI is the non-profit global indigenous peoples organizations who work to confront the criminalization, violation, and impunity against indigenous peoples. I would like to thank everybody and welcome everybody who is here today. Today is a very good day, a very important day, and I hope we will enjoy the rest of our conversations, although we are only be able to do it during this time through online, which is this Zoom meeting. Thank you very much for everybody. First of all, I would like to also welcome other global directors of board of directors of IPRI is here. I see Joan Carling here. I would also like to welcome my sisters, brothers at the Secretariat of IPRI. And for this digest, Sanyaru, it is the indigenous word from indigenous peoples in Mexico, that meaning path. Alan Kai will explain this later in his presentations about this digest. We hope this digest, we are planning to do this every 2 years, just to allow everybody to understand that the UN declarations on the rights of indigenous peoples has, as a part of the international human rights norms and standards, has been accepted and has become jurisprudence at global level, at regional level, and also have become legislation at national level through different countries, from Sweden to other countries. We need to have this. This is very important to us. This is not just to raise awareness, but to see, to give hope for indigenous peoples and our allies and our friends, that the standards, the minimum standards that is set in the UN Declaration on the Rights of Indigenous Peoples have become jurisprudence and legislations in different parts of the world. Although we continue to suffer violations and criminalizations to our human rights and fundamental freedom of indigenous peoples, but from different parts of the world, especially at global level and also at regional level, will allow us to keep our spirit high for indigenous peoples to continue to believe and continue to fighting for our rights. This is including for us in Asia and also many parts of the world where the situations of indigenous peoples is not getting better. There are many what we call rollback in terms of how the state, the government, the corporates have been treating us as indigenous peoples. But there is a hope as long as we continue to fight. I think that's the message we want to send to the world through this digest, Sanyaru. In the case of my country, in Indonesia, although our government continue to say there is no indigenous peoples in Asia, especially also in Indonesia, because all of us are indigenous, but we don't believe them. We believe that our rights, our collective rights as indigenous peoples, is protected and guaranteed by the international human rights standards, especially the UN RIP, prevail and will remain there. Doesn't matter they recognize us or not. We believe in using the international human rights instruments. We have been using UN CERT mechanism. We have been using special rapporteur mechanism. We have been using all the other mechanism that is available. And the last thing that we use is the ILO 111. For us, this is very important. And it was the very first step we use because we do believe our traditional occupations is not just occupation. Our traditional occupation is not just it's not just about our livelihood, but it is our collective rights to our land, our culture, our identity, and our political systems as indigenous peoples. That's why we do believe that violating, taking away our land and territories and resources in indigenous territories are violations to the ILO 111. And this is the concrete examples. This will not, winning the case will not return immediately our land, territories, and resources. But this is to provide us with a platform, with a tools to continue to fighting to get back our land, who have been stolen by the companies. And this is something that we need to keep as indigenous peoples, as the friends of indigenous peoples in our heart, that all these things will provide us tools, will provide us platform to continue to fighting for our rights. I thank the speakers. I thank Rosa is here. I see also Mauricio here. Hi Mauricio, welcome, and Laura. And I hope through the sharing of their experience and their thought later, the ideas we will know, we will continue, to carry on our fighting
Les idées
as indigenous
continueront
peoples, as the friends
à
of indigenous
porter
peoples,
nos idées, notre lutte,
as the brothers and sisters of indigenous peoples, wherever we are and whatever we do in our daily life. I would again thank you very much everybody, and my sister Monica, thank you for moderating this very important meeting, the very important launching of the Sanyaru, and I hope we will have the rest of the sessions will be very enjoyable and fruitful. Thank you very much. Kuresumanga.
Muchas gracias, Ruca. Muchas gracias.
Thank you very much, Ruca. Thank you for your kind words. Thank you for this comment. Indeed, from any place, from any space, we need to fight in favor of the rights of the indigenous peoples. And yes, we'll continue with this launch of the legislation and jurisprudence digest. We would like to thank everyone who is participating in such an important event. Now, I would like to introduce our colleague, Alancay Morales. He is the General Coordinator of Political Incidents at IPRI. He will give us a presentation of the digest so that we can better know what it is about. Go ahead.
Thank you very much, Monica. And yes, thank you, Monica. So we're very excited today because we're launching the first issue of the digest on legislation and jurisprudence. And basically, I just to provide a bit of context on what brought us here. After the 2007 adoption of the UN General Assembly of the UN Declaration on the Rights of Indigenous Peoples, we have had numerous developments at all levels around the world in terms of how the UN Declaration is being used as the standard when it comes to Indigenous peoples' rights. So in all this development, we have policies adopted by different UN bodies, as well as cases being filed that use the provisions of the UN Declaration in different countries around the world. The same with treaty bodies and how the standards of the UN Declaration are affirmed in their decisions and so forth. And that's one end, but the other one, echoing what Ruca was mentioning, we are also facing discontinuous threats against Indigenous peoples in relation to our rights, our land rights, in general, our collective rights. So on one end, we're having all these developments happening, but on the other end, the threats are continuing growing. So part of what IPRI analyzed and whether there was something that we could do to help us in further these developments that are happening around the world. And one of the gaps that we identified was that there were not many references compiled on, and also like up-to-date references of what was happening around the world in relation to Indigenous peoples' rights. So oftentimes we hear about cases because there is a publication shared by one of our brothers or sisters, but not necessarily because we have a reference that provides us with that. And that led us to the development of the digest. And while we were working on this, some of the issues that came up were that besides it being only like a digest where you can find references of these cases, is that it could help us a tool for education purposes, for legal actions, for advocacy as well. And in the mid and long term, we see it as a tool that will help us track what the developments are, how the rights of Indigenous peoples are evolving, let's say, in terms of interpretation by different bodies at the global all the way to the national levels. And precisely in that regard, it's what to expect in the digest. So in this initial issue of the digest, we're covering cases from the global level, regional mechanisms such as the African Commission on Human and People's Rights, as well as the Inter-American Human Rights System, both the Commission and the Court. And then we have various cases around the world. So the title is, as Ruca mentioned, Xañaru is a Purepeche word from an indigenous people in Mexico. which is the path. And so we're hoping that this will open a path and that we continue building on this path. We're basically aiming for having this digest being published twice a year, and it will be uploaded on IPRI's website. And we'll start developing certain functionalities around the digest so that it can help better in the different needs that Indigenous peoples or practitioners or allied organizations may have in relation to our rights. And just to give you an overview of what we have included on this first issue of the digest, we have cases from different treaty bodies, cases from addressed by the UN Committee Against Torture. We have the UN Committee on the Rights of the Child, the Human Rights Committee, and also the UN Committee on the Elimination of Racial Discrimination. And echoing Ruka, what she mentioned, and something I would like to highlight here is that we have a report by the ILO governing body. And usually when Indigenous peoples talk about the ILO, our standard or the reference instrument is ILO Convention 169. But rarely do we consider other conventions within the ILO that could help further or that could actually present some issues. And so this report is on a different convention, on 111, which is on the discrimination on employment and labor. And as Ruka mentioned, there were some issues addressed there that on one end are concerning for us. And I would invite you to read the digest. It's just like a one page that covers the issues of that case. But again, something that we feel it's important to highlight is that just from the cases that are compiled, we can see that there are different avenues that can be used to protect or to continue our advocacy as Indigenous peoples. Then at the regional level, as I shortly mentioned before, we have cases both from the African Commission on Human and People's Rights, from the Inter-American Commission on Human Rights, and the Inter-American Court of Human Rights. And basically what we are seeing here are cases, and a couple of them are rather important for those following up on the issue of business and human rights. So for instance, just quickly mentioning the case of the Buzos Miskitos, or the Miskito divers versus Honduras, that it incorporates the standards of the UNGPs. The reading of the Inter-American Court addresses some of these issues of the UNGPs in the decision. And another thing that I wanted to share as an experience, and why this is also relevant, is that back in 2007, the Inter-American Court on Human Rights decided on a case in Suriname of the Saraka people. And shortly after, many of the analysis and the decisions adopted by the Inter-American Court of Human Rights were referenced in the Endorois case in I'm sorry if I'm not pronouncing correctly the name, but in the African Commission on Human and People's Rights. So we're seeing the way in which two different instruments, two different jurisdictions are addressing similar issues, and how might one feed into another one. And in a way, we're seeing the digest as giving that possibility of opening those references so that people can advocate on what developments are happening elsewhere. And then at the national level, we have cases ranging all the way from New Zealand and Australia to Peru and Ecuador, a couple of cases in Canada, the same in Belize, Sweden and Norway, and Uganda and Kenya. And again, the cases are on different areas. Some of them have to do with extractive industries in these countries. Also cases where the rights of indigenous peoples, the land rights of indigenous peoples are affirmed, or when lack of consultation leads to, or lack of consultation and consent leads to a favorable judgment, let's say, for indigenous peoples, as was the case for the Sami people with the Fosen wind farm in Samiland. So we invite you again to look into these cases, and because we're very excited, let's say, for the first digest, but also looking ahead on what we're aiming for with the digest. We're seeing the possibility of furthering advocacy actions for indigenous peoples, but that it can also serve as an education tool. And how can we better adapt the digest or complementary resources that may be needed for enhancing that education work? And just to share with you, like, what this has also meant for us, because with the review of cases, let's say, on the UN Committee Against Torture, we came to analyze and see ways in which the Committee Against Torture was addressing certain issues regarding indigenous peoples. So having this more holistic view of the way it's being addressed, it gave us a new understanding and explore ways of using this, let's say, the provisions in the convention, as well as the mechanisms available by the committee to address issues regarding indigenous peoples, right? So it has been also a learning process for us at IPRI. And we're aiming for this to grow, for people to eventually start sharing with us cases that we can include in the digest. And if at some point something can be provided as support for a community that is addressing a specific case for advocacy purpose or similar things, then this is something that we're aiming for with the digest to be used, and that we hope we can adapt or accommodate certain needs to enhance its effectiveness. And just to close my remarks, we're open to your ideas and suggestions, so please feel free to share them with us later through the chat box or in the Q&A. And thank you very much for the time.
Muchas gracias, Alan Kay, por esa presentación.
Thank you, Alan Kay, for that very important presentation. And we're very certain that this will be a great contribution that will help to strengthen, to defend the rights of indigenous peoples and their defense. And then in the link, you will share with us where you can download that document and you can read it, as Alan Kay mentioned. So now we will continue. Now we're going to have a roundtable discussion, and now we will have very important individuals that will help to inform us on this discussion. And now I will read the biography of each one of our presenters today. And this will also we'll have the questions, but Joan Carlin, the Global Director, will share this with you. So I will now share with you the biographies. We have Mauricio Terena. He is an indigenous lawyer from the Terena people. He is a legal advisor from APIB's legal department. He has PhD student in social anthropology at the University of Sao Paulo. He's a member of the Criminal Justice and Indigenous Peoples Observatory. His areas of work are environmental protection, sustainability, territorial conflicts, indigenous policy, combating against the criminalization of human rights defenders. We'll also have Laura Fisher. She is a qualified attorney who serves as a human rights advisor at the sector program Human Rights of GIZ. Within her position, Laura advises the German Federal Ministry for Economic Cooperation, BMZ, on the implementation of human rights approach in the German development cooperation, including the promotion of the rights of indigenous peoples. Before joining GIZ, Laura wrote her PhD dissertation focusing on the right to participation of non-state actors in the international environmental governance. Then we also have Rosa Celorio. She is now working as Dean of the Family Associate Dean Distinguished Professional Lecturer for International and Comparative Legal Studies at George Washington University Law School in Washington, D.C. She worked for more than a decade as the senior attorney for the Inter-American Commission on Human Rights. And she held several leadership positions, including the supervision of all the legal work performed by special rapporteurs on the indigenous peoples, racial discrimination, women, LGBTQ persons, and she currently serves as the International Dispute Human Rights Resolution Authority between the Mayan indigenous peoples and the government of Belize, and a senior advisor to CEDAW on the new general recommendation of indigenous women and girls. These will be our panelists on this roundtable. Therefore, I now want to give the floor to Joanne Carling. She is the Global Director of Indigenous Peoples' Rights International, IPRI, and she will be moderating this discussion using these guiding questions that we have for each one of our panelists. So now I turn the floor over to Joanne so that she can moderate this session for this discussion with the questions and answers with our panelists. You now have the floor, Joanne. Take it away.
Yeah, thank you. Thank you for this, Monica, and also welcome to our panelists for this interesting discussion. So not to lose time, let's start with Mauricio Terena. Can you share to us your ideas on how this tool on legal and jurisprudence can be useful in legal and policy advocacy in the work of a national indigenous organization such as APIBI, and how can this digest also be adapted for education and use by grassroots organizations? So Mauricio, you have the floor.
Bom dia a todos e a todas. Queria inicialmente agradecer. Good morning, everybody. I would like to thank the invitation. It's a pleasure to be here. And this is a rather complicated situation for the indigenous peoples in Brazil. I am here in the eve of a recent strike against the indigenous peoples in state of Mato Grosso do Sul. To answer the questions in an objective way, this material is highly valuable, considering that here in Brazil, we indigenous peoples, we're not acknowledged as people of having our rights. The present government by Bolsonaro has systematically, whether by judicial steps or administrative steps, have been trying to restrict the access of indigenous peoples, whether to justice, whether to our rights. So any international movement of organizations that would insist on international treaties of human rights, to which Brazil is a signatory, reinstates these rights, reinstates that the indigenous peoples must be consulted, that reaffirms that indigenous people should not be assimilated. This is a document that will certainly give us a theoretical and technical support to strengthen our arguments. So with no doubt, APIB, the Articulation of Indigenous Peoples of Brazil, has a large interest in to collaborate and use this material and to build ever more international mechanisms regarding the rights of indigenous peoples in Brazil.
Okay, thank you, Mauricio, for that positive and remarks on how the digest can be useful to further strengthen the movement of indigenous peoples in Brazil. And I would like to also take this opportunity to again express our strongest solidarity with the indigenous peoples in Brazil in this time. As you said, that it's a very difficult time for our brothers and sisters in Brazil because of the continuing oppression by Bolsonaro. Now we move on to Laura. Laura, with the GIZ, what relevance does this digest have with an institution like you in government, and how could this digest be useful in the work of in the future work of GIZ, or in general for development agencies? So Laura?
Yes, good morning, good afternoon, everyone. First of all, I would like to congratulate Indigenous Peoples' Rights International for this very timely and important digest of legislation and jurisprudence on Indigenous Peoples' rights. And you already introduced and said German Development Cooperation is committed to a human rights-based approach. This is our guiding principle. And our objective is to support partner countries in fulfilling their human rights obligations, including indigenous people's rights. And you also mentioned the ILO Convention 169 as the convention that is very often mentioned when it comes to indigenous people's rights. And Germany also ratified this convention, and it entered into force some 10 days ago. And so for us, this is a strong political signal to continue our engagement for the protection and promotion of indigenous people's rights at the international level and also in our partner countries. And in this regard, the digest is an important contribution in applying this rights-based approach. So I very much appreciate that you use this word as a path, because I think it's a path we are on. Puka mentioned it's a path that is not an easy path. But I think the digest is a good way and a good tool, so we are better equipped on this path. And I very much appreciate that the digest looks at the international, national, but also regional levels, because in advising our partners, we often take into account regional jurisprudence or also national case law in neighboring countries, because they bear a considerable political significance. And often they also serve as a guideline for subsequent practice in other countries. So in our view, the digest is an important tool for that, but also an important contribution to address the implementation gaps concerning indigenous people's rights. So we have noticed that in our partner countries, for example, they have ratified several international conventions, such as the mentioned ILO 169 convention, but also they endorsed UN declarations, such as the UN Declaration on the Rights of Indigenous Peoples, but still domestic translation and implementation of these instruments often remain inadequate, and they fall short of fulfilling international and also regional standards. In this regard, we are also aware that of the importance of jurisprudence to clarify and reassert indigenous peoples' individual and collective rights to self-determination, free, prior and informed consent, their right to land, and also to decide their development priority. So one recent example that comes to my mind is the second Ogier judgment delivered by the African Court of Human and People's Rights, which recognized the Ogier's right to an unhindered use of their land, while stressing also the need to act in accordance with Ogier's custom on all matters concerning development, conservation, or investment on their lands. And the Inter-American Court of Human Rights has also delivered some landmark decisions in the same direction, including the right to free, prior and informed consent and consultation. So one notable example among others being the Sarayaku judgment. And these judgments, but also the examples we heard of before in the digest, are a strong signal to other countries about the importance of indigenous peoples' rights. And at the same time, they also indicate to affected communities, to human rights defenders and NGOs worldwide that judicial avenues are available, and to hold states accountable, and also to seek remedies when it comes to the lacking implementation of indigenous peoples' rights. So what could be the use of the digest for our future work in the GIZ, but hopefully also for other development agencies. So in pursuing this human rights-based approach, at the GIZ, we aim to strengthen the capacity of state institutions as the duty bearers to respect, protect, and fulfill human rights. And part of this capacity development requires that we provide technical but also legal advice to state institutions, how they can fulfill their obligations in regard to indigenous peoples' rights, for example, concerning consultation or demarcation of indigenous territories. And the digest, I think, can facilitate our work, since the jurisprudence and examples it collects offered very important clarifications on the interpretation of international, national, and regional standards, which is of importance for advising our partner institutions. But also on the other hand, because we also support the rights holders by, for example, assisting civil society and indigenous peoples in acquiring full knowledge of their rights, and also the various avenues available for claiming such rights. I think this could also be integrated in projects entailing, for example, training activities for civil society. So in general, I think the digest will make it easier for us to keep track of recent developments concerning indigenous peoples' rights, and it will also be a precious tool for our country-specific analysis, and also a good repository of recent legal developments on which we could draw upon when we propose new projects.
Wow, Laura, that's really captures the different use, I think, of this digest. But I just want to reiterate what you mentioned in terms of addressing implementation gaps, and also the clarifying the concept of rights. I think those are really important contributions as well of this digest, as you have mentioned, along with the other usefulness. And also just to mention here that IPRI do appreciate also the support GIZ and BMZ is providing to our work, and so we will definitely continue to work with you also in the use of this digest. So thank you, Laura. Now we move on to Rosa. Rosa, given your experience in comparative law, what is your impression and assessment of the digest that incorporates cases on indigenous peoples in multiple jurisdictions and countries? And also, if you can highlight that as an expert in human rights in relation to women, for example, the work that you've been doing on CEDAW, what could make this digest more useful for practitioners or researchers? Rosa, you have the floor.
Thank you so much, Joan, and thank you, Monica. Thank you, Alan Kai, for the invitation to this wonderful event. And I want to congratulate you for providing us with such an important tool. I was so excited to hear that you had worked on this digest, and there's a number of reasons, why I'm very excited about this. One of them is that I think knowledge is such a critical ingredient to work related to human rights issues, to work related to advancement of indigenous people's rights. And what happens a lot in international law is that we issue from the global, from the United Nations system, but also the regional systems, and even at the national level, we issue these decisions and we develop all these standards, but they're not necessarily known. I think it's actually one of the most crucial voids we have in international law. And I think when you see a digest like this is a very important tool to advance knowledge of what Indigenous people's rights are. And also, what I think is very important when it comes to jurisprudence is that jurisprudence provides examples. So, for example, when we're talking about human rights and Indigenous peoples and how they're connected, more often than not, we do need concrete examples to explain to governments what that means, to explain, to all the parties involved in the implementation of Indigenous people's rights, what to do and what not to do. So that's why I'm a big fan of jurisprudence. I think it's very important. And I think it's wonderful to have a tool now that actually consolidates a lot of the jurisprudence. And I was very happy to hear that the plan is to update, right? Because I do think it's very important to have a periodic update. And also, I think one of the challenges also that we have in international law is that it's not necessarily easy to find the jurisprudence. I worked for more than a decade at the Inter-American System of Human Rights. I love the Inter-American System. I'm a fan of the system. I'm a believer of the system. But I remember how difficult it was, right? To make the work known, to make all of those wonderful decisions, from the Inter-American Court that were mentioned by Laura, to make them known, right? Across the board, not only at the international level, but at the regional, national, and local levels. And even for people that are the most that are really the intended beneficiaries, more often than not, they don't know that the jurisprudence exists. The other thing is, I think it's very important to have jurisprudence on Indigenous peoples documented, because this is a very important part of the effort to achieve legal protection, and not only recognition of Indigenous peoples, but also recognition of collective rights of Indigenous peoples, of collective property rights of Indigenous peoples. And I mean, not only in the law, but also in implementation. We have been talking about the problems, the massive problems that we have with implementation. And I express all of my solidarity with Mauricio and the difficult situation in Brazil. And there's also many other situations across the world, right? This is a very, very dire area of international law where we still need a lot of implementation. But also, I think when you think of jurisprudence and all of these legal developments, this is critical to inform the development of tools also that are being used on the ground. Like, for example, free prior and informed consent protocols. I've been, for example, participating in this process in Belize. I'm very honored to be working with the Maya peoples in Belize, and also the government, and also with the Caribbean Court of Justice. And for example, one thing that I've been doing is studying the development of consent, right? Where is consent in international law right now? Where is consultation in international law right now? And this is an evolving area of the law, right? Every day we have more judgments, right? From different global entities and regional entities and national entities of what consent is, right? But this is not necessarily informing, all of the efforts that we have. So I think the digest is a way to motivate this kind of research, motivate that this kind of decision serves as a valuable input, right? When designing, this free, prior, and informed consent protocols and other efforts that are very important on the ground. I think, as was already said, I think this is a vital tool also for education purposes and for advocacy purposes. And what I mean by education, I don't mean only governments. We have to educate governments, but I think when it comes to Indigenous people's rights, there's so many actors that we need to educate. Businesses, for example, extractive industries, for example, third parties need to be educated as well. Right? Even human rights defenders, for example, there's so many different kinds of actors involved, in the advancement of Indigenous people's rights. And I think this can be a very important tool when it comes to education. I think another very important value of the digest is to see the evolution of the use of the United Nations Declaration on the Rights of Indigenous Peoples, and how it has become the authoritative standard on Indigenous peoples, but also the way it's been adapted and interpreted when it comes to the content of its provisions. Historically, we have seen that this is very important for any sort of international instrument, to see how it is applied, to see how its content is interpreted, and to also exemplify how this instrument can be used or not used. I think it's wonderful to see, for example, all these United Nations committees using UNDRIP as the standard. You know, I'm currently working with CEDAW, with the CEDAW committee, and it's so wonderful that for them it's a given that UNDRIP is this authoritative source of international law when it comes to Indigenous peoples, and it should be, right? You know, and when it comes also, just to close this section, I think another aspect in which I think a digest is so valuable is to connecting the dots. Like, for example, one thing that we're working on in international law is how to understand the relationship of Indigenous people's rights with other areas of the law. Joan mentioned women, for example. I work a lot with women's rights. And for example, right now, something that I'm doing with the CEDAW committee is that we are getting to a process in which we are basically demystifying or connecting the dots when it comes to what it is an Indigenous woman. You know, these two sets of rights, Indigenous peoples and also women's rights, how do they combine, you know, when it comes to Indigenous women? And what does that mean in terms of implementation of the rights on a daily basis? What is a form of discrimination? And also connecting, like when you violate the right to self-determination, when you violate the right of free, prior, and informed consent, that's also a form of discrimination against Indigenous women, right? So at the end of the day, I think this kind of digest provides very important research, you know, for that kind of effort and to actually develop standards, right? To not only know what the standards are, but we're trying to push the boundary too, right? So at the end of the day, it also allows all these bodies, and I saw this in the Inter-American Commission as well. When I was at the Inter-American Commission, every time we were trying to innovate, right? We were always trying to push the boundary of the standards. We needed to know what the standards were, right? To be able to know what our starting point was, to be able to move forward. And I think one of the wonderful things about a digest like this is that it gives us a starting point, right? We know the starting point, and then it's much easier to figure out how to be innovative, how to be groundbreaking, and also how to respond to current needs and how to connect the dots as well. You know, Indigenous peoples and women, for example, Indigenous peoples and the environment, for example. You know, I saw that the digest has the Psaki decision. That's wonderful, right? We're all looking at the Psaki decision very closely when it comes to climate change, when it comes to extraterritorial issues, you know, and it's very important to connect those dots as well, because Indigenous people's rights, you know, and the challenges occur in a context, right? And it's good to understand how all of these areas of the law connect again. Again, congratulations. And it's wonderful to see this work from Indigenous People's Rights International. And thank you for your invitation to be a part of this process.
Yeah, thanks, Rosa. And you've really covered a lot of ground in terms of the usefulness. But I want to highlight two of what you mentioned. One is the issue of the education, that it is actually a very educational tool to different actors, from states to even human rights defenders, human rights institutions, but also the issue of the evolving interpretation in actual practice of the UN Declaration on the Rights of Indigenous Peoples, which is really very, very important now. As mentioned earlier by Ruka, there is a regression or a setback, right, in terms of how states. So this is reminding us that, hey, we need to, you know, implement our international human rights obligations in relation to Indigenous peoples as it affects them. So this is really thanks, Rosa, for those encouraging words for this tool, the usefulness of this tool. So and unless Mauricio wants to add, is there anything, Mauricio, that you want to add before I open the discussion? I open the floor for the question and answer. Maybe if there's anything you want to add. Mauricio?
Obrigado. Bom, eu gostaria só de ressaltar mesmo a importância.
Thank you. I would like to highlight the importance of this tool in the sense that, according to the judiciary in Brazil, has been considered as incredibly conservative judiciary, because they do not accept us as an ethical group to have an international compilation of these rights reinforce our arguments and our existence, reinforce our right to life. So without any doubt, it is a document that will allow us to future generations. Brazil doesn't have many indigenous lawyers because until the years of the 88, the Constitution didn't think we were according to the law, we were going to be forced to not to be integrated into the non-indigenous society. So this colonial thinking continues to have legal tools in order for indigenous lawyers in the judiciary will reinforce the argumentation is very important.
Okay, thanks for that, Mauricio. I'm glad you mentioned about indigenous lawyers because that's also one of the target of these tools that indigenous lawyers can also use it to further advance the recognition and protection of indigenous peoples in law and practice. So thanks for that. And now we open the floor for some questions from our participants. I see that there is a question in the box in the Q&A. I will read it and maybe one of our speakers can respond as appropriate. The definition of indigenous peoples is not cleared in Indian constitution, though India has signed ILO Convention 107, 169 and support UN DRIP. But the definition is not cleared in Indian constitution. Without proper definition, how the indigenous peoples of Northeast India achieve the results of UN DRIP. What will be your comments? So this is a question from one of our participants from India in Asia. I'm not sure if any of you, of the speakers are familiar on this, but just to mention that we in IPRI produced report on the criminalization of indigenous peoples in India, and it provides the definition or how indigenous peoples are defined in the context of India and how they are being criminalized, but also what are the laws that are actually recognizing the rights of indigenous peoples in India as they are called scheduled tribes or Adivasis. So I would like to that the one who asked the question, if you can, we can share to you the report that we made in on India, which I think will respond particularly to your question. Are there any comments from our panelists on that question? If none, is there any other question that I would encourage participants to use the raise hand or the Q&A button or even the chat if you wish to ask questions? There is one comment, I think, from somebody in Germany. No, so how can? Yeah. It's I'm not clear on this. Okay. Is there any? I don't see any raised hands, or can somebody notify me if I'm missing out in terms of questions or hands raised? And how much time do we have? Do we still have 15 minutes left? Is it?
Yes, Joan, we have like 15 minutes left.
Okay. We still have 15 minutes. So we're open. Like I said, we are open to this is the time for participants to also share your views. If you don't have any questions, please to briefly also share your comments. I see now one, how much would indigenous law be taken into account in the digest? I think this is a question to us in IPRI. Would you like to respond to that, Alangkay?
Yes, of course, John. And I think it's a very important question. We have not fully discussed about the incorporation of indigenous law to account in the digest, but as in the end of the presentation of open to ideas and suggestions, I think it's important to consider this as well, how the indigenous legal systems are addressing different issues. So, and this could be also a learning lesson for other indigenous peoples that might be strengthening their justice systems. So we take note of the question made by Claudette, and I think it's something that we need to further discuss and consider of how these developments made by indigenous peoples around the world within their own legal systems, how they can be considered. Yeah. Oh, I forgot to turn my camera on. Apologies.
Do we have any comments on that, or for participants also to have any comments? Is there any comments in relation to indigenous law from my end? I think it's important to also see what is the areas of consistency of indigenous law to international human rights law, and where there are gaps or even conflict, and in the context of the right to self-determination, how will that play out in relation to the well-being and of indigenous people? So I think that's actually a very interesting field. At the moment, of course, we are covering what is international law. That is fundamental for the survival and development and dignity of indigenous peoples. But yeah, I mean, this is within the context of what is called the legal pluralism. How is legal pluralism going to play out in relation to upholding the rights of indigenous peoples? Because we are also entitled to the recognition of our customary laws. Right, so that should also be part of the legal jurisprudence that we are collecting. So I think that's where there is the convergence, if I may say. Okay, anyone else who and the floor is open always for our panelists to share their views as well, or if there are key messages that you still want to share, please feel free. Anyone else, Joan, from the participants?
There is another question regarding the digest covering jurisprudence from the European Court of Human Rights.
Okay.
Just to briefly note that basically what we did with this digest was to cover the main developments that we have had over the past 2 years. We didn't go before that, but the idea is to start updating this as we have developments happening. So if, for instance, the European Court addresses a case related to indigenous peoples, we would definitely cover that. So it's not limited only to, let's say, the regional mechanisms in Asia and Africa, but those are the ones that, in the case of this current issue, the references that we included. But in case there are any developments in the European one, those would we would make sure to cover them as well.
Yeah, and maybe just to add, we are also collecting historical jurisprudence, the jurisprudence done way that has been what's the term, that has been used as a landmark. So we're also gathering that sets the jurisprudence in further recognizing and upholding the rights of indigenous peoples. So that is one because, as Alangkay said, for the first issue, it's covering only the past 2 years. So the historical ones, the landmark, if I may say, cases in the past, we are also putting it together as one special report, digest report. So I think that can cover any landmark decision in the EU as it relates to indigenous peoples. Okay. And I hope we'll be able to, we've already also started collecting the one for the second digest, and I hope we'll be able to issue this in time for the anniversary of the UN Declaration in September. So just to let you know that where the work is currently being undertaken, so that hopefully we can issue the second digest for as part of the anniversary of the adoption of the UN Declaration. So it's to remind the international community that this we need to consistently use this tool to uphold indigenous people's rights. Okay, seems like we're not getting any more questions or comments.
Someone, Karine Rinaldi, raised her hand on the chat.
Okay, yes. Can you have the floor? Karine, you have the floor. You can speak, Karine.
Do you hear me?
Yes, we do.
Great, thank you for allowing me to take the floor. I wanted to ask you if the digest will also comment or criticize the decisions that are coming from treaty body, in addition to cover the jurisprudence, if you're doing some analysis to criticize the decision, because well, actually, I work at OHCHR, and I work for the treaty bodies in the section that draft the decision for the treaty bodies examination and adoption. And honestly, sometimes it's difficult to make whole experts understand really indigenous people's rights. So sometimes the decisions are not so good, and they could be much better. So if there is a criticism coming from you, from the digest, maybe this could help them to understand and to develop even more the jurisprudence. And just to give you an example of a recent case adopted by CERD against Ecuador, it's really important case because it's recognizing the competency of indigenous traditional authorities to officiate marriages in application of indigenous people right to self-determination. So this is really good. And as a measure of reparation, they are asking Ecuador to take all necessary measures to enter in the civil registry marriages officiated by traditional indigenous authorities in accordance with their own custom and customary law. But we had an issue because they said as long as they are not contrary to domestic requirements. So this is a problem if we think of extended family, which is recognized in the American Declaration of Indigenous People Rights. Extended family with, for example, one indigenous man married to marry woman, or I mean, this could be contrary to what is recognized by the American Declaration. So yes, I wanted to ask you if you're commenting the jurisprudence in order to have some room for discussion with committee members and for them to develop it even more. Thank you.
Yes, thanks for raising that. We actually have that in our digest in the context as you've mentioned, the right to self-determination, right to family life, right to choose your partner is there. And in relation to your question on do we engage with these treaty bodies to further strengthen the recognition? We do. So, for example, now we've also been engaging with the CEDAW to strengthen further their interpretation on the indivisible exercise of the individual and collective rights of indigenous women, for example. So that's an area that we have also been engaging, directly with members of the treaty bodies. To further strengthen the recognition and their interpretation of the rights of indigenous peoples. So it's good that you pointed that out. So in case there are areas where you think we need to raise our voice, please feel free to approach us. So we will be notified. Yeah, because I think this will be taken in good spirit and in a constructive manner because of our common aspiration to strengthen indigenous people's rights recognition within the UN system. Thank you. Thank you for that comment. Anyone else? Now we're getting more this is another comment from India. There is another Rosho is there any question? Rosho, another question in general. Okay, there is a question here, another question in the general chat. In terms of strengthening the knowledge of indigenous rights for indigenous peoples, it is often difficult to transmit legal terms. Are you planning to produce materials that are more understandable for indigenous communities? The response here is yes, we do. We really want to make use of this to reach out to as broad as possible among indigenous communities. The challenge though is the resources, right? The availability of resources to enable us to do this important work on simplifying laws to better for indigenous peoples to understand. But as an objective and as an aspiration, we do, of course. So we just need to find the resources to be able to do this, including perhaps volunteers to help us in doing this, like lawyers who can help us simplify, put it in a layman's language, and translators, and that can also help us translate in different languages. Definitely that kind of support is needed so that we can work together to reach out more. So this is also an appeal to those who can help us advance further the reach of this digest by helping us simplify and translating it to different languages so that we can reach out to more. Thanks for that. I think we're now reach our time. So I just want to call on our speakers for your concluding remarks. 1 minute for each for any concluding remarks or any advice that you can share to us or to our audience in relation to strengthening the legal recognition and practice of indigenous people's rights. Let's start the other way. First, I will call on Rosa.
Thank you, Joan. I wanted to thank again, Indigenous People Rights International for this valuable tool. And I just wanted to say 2 things quickly that I think it would be great if you can translate it in different languages, the digest. Like, I think that would help reach, more audiences and more people that could potentially use it. And I think also at the end of the day, I think it's very important to work with academia. I sit in a law school And I think, for example, Indigenous people's rights should be part of any course related to international law or international human rights issues. I teach a number of human rights issues. I always incorporate Indigenous people's issues, you know, in my courses. And I think this is a fundamental area in international law. And I think a digest like this helps educators as well, you know, helps educators, you know, incorporate basic principles that all lawyers, you know, should be aware of, you know, when it comes to Indigenous people's rights as well. Thank you again, and congratulations for this wonderful work.
Thanks, Rosa. Laura?
Yes, thank you very much also from my side. And I would also very much appreciate the simplifying and also the translated tool, which I guess must be a lot of work ahead. But I think it's a good idea. Another just minor suggestion that came to my mind was it would be great if you could sort the option of sorting the relevant legislation and jurisprudence by regions. So you could get like an overview what happened in each specific context. Maybe that would also already be a step ahead for simplifying a bit. But I very much appreciate that the launch of the digest. And I think it's great, as Rosa also mentioned, to connect the dots also with different rights, such as women's rights or children's rights. So yeah, the path, as you said, is still ahead, and we are very happy to support and try to be a part of it. Thanks for having us.
Thank you, Laura. And Mauricio?
Bom, eu queria agradecer o convite. Eu queria dizer que estamos vivendo.
I'd like to thank the invitation. We are going through difficult periods, and the climate changes where the planet Earth is asking for help. We, indigenous peoples in Brazil and the world, it's us who protect the forest. So a legal document could strengthen our action, and that legitimate us, that tell to the state and to the governors that we are subjects of right and we know to protect the land, because nobody eats money. These are very important documents. So I would like to thank this document that strengthened our self-determination of the Brazilian indigenous groups. I'm sure we're going to use it very much in the Observatory of Criminal Justice of Indigenous People. Unfortunately, the Brazilian government used their own judicial system to criminalize us. So such tools will support us in our fight. Thank you very much.
Thanks, Mauricio. Thanks for reminding us that the protectors of the land, the protectors of the environment needs protection by law. And that is an important reminder to all of us to do the best we can, to use the legal system and use this digest to further advance the recognition of our rights in law and practice. So on behalf of the Indigenous Peoples' Rights International, I would like to thank all our panelists. Thank you for your encouraging words on how these digests are going to be used, but also your advice on how we can continue to improve and do outreach of this digest. And also thanks to all the participants in this event on the launch of the digest. And thanks to also my colleagues and all the interpreters for being with us in this important discussion. So thank you, everyone. And again, just to mention that we will have another event tomorrow, which is on the update on the situation of criminalization of indigenous peoples, and also highlighting what's happening now in Colombia, which I think gives us some glimmer of hope with the result of the elections, but also in relation to the peace agreement, which is actually one of the topics of the MRIP. And finally, another side event on Thursday in relation to the issue of incarceration of indigenous peoples. And we've done this with university students who have volunteered to do the work. So they will present us what the research they have done, but also the challenges they face in doing research. So I invite everyone in this event to join us again tomorrow and on Thursday for another interesting topic in relation to indigenous peoples. So again, thank you to everyone. And I wish you a good day wherever you are. Thank you.
Thank you, Joan. Take care.
Thank you.
Muchas gracias también.
Thank you,
Muchas
Monica.
gracias, Joan.
Thank
Muchas
you,
gracias a
Julia.
todos,
Thank
a
you,
todas.
Alankay.
Un abrazo.
Bye-bye.
Thank you.
Bye-bye.
Thank you to everyone. Thank you.
Bye-bye.